Jackie, here we go. Rules Committee come to order, and thank you very much for joining us today. I'm a little bit better, Jackie. I had a coughing fit yesterday, had to go to the doctor. It's amazing what a Z-Pack can do to help you in 24 hours.
There you go.
I'm at least a little bit better. Good afternoon and welcome to the Rules Committee today. The committee will consider H.R. 5226, the Regulatory Integration Act of 2016, and H.R. 5351, to prohibit the transfer of any individual detained at the United States Naval Station, Guantanamo Bay, Cuba. Each year, federal agencies promulgate thousands of new regulations and impose billions of dollars of regulatory cost on the American public. Already in 2016, this administration has imposed $63 billion in new regulatory costs and has proposed an additional $16 billion in regulatory costs that, of course, you and I understand get passed along to consumers, cause jobs not to be created in the United States, and causes prices to be higher. In issuing these new regulations, agencies are required to go through a period of notice and comment, which allows the public to review a proposed rule and offer comments to the agency. H.R. 5226, Chapter 3 of Title 5 of the United States Code, to require the publication of information related to pending agency regulatory actions. This legislation increases transparency into the proposed rule process by requiring agencies to post in a central location all the public comments that are issued during a proposed rule stage. The second bill under consideration is H.R. 5351, which will halt all transfers from Guantanamo Bay detainees until 2017, until the NDAA is signed into law or until a new administration takes office. Halting Guantanamo Bay transfers for the next few months prevents the possibility of rash and sudden transfers, which might be driven by a desire to hurriedly fulfill what I believe is a poorly conceived 8-year-old campaign promise by President Obama. Many recent Gitmo transfers have been conducted hastily and without the careful diligence necessary to ensure our nation's security and information provided to Congress before these transfers take place in a timely manner. I would like to welcome the gentlewoman who is a very dear friend of mine from Indiana, Congresswoman Jackie Walorski, on the first panel, as well as Ranking Member Smith. Mr. Smith is a very deep and dear friend of mine. He is a man who I've known who not only cares about the United States, but about our standing in the world, and I'm delighted that both of you are here today to add your comments to this very important issue. And I want to thank both of you not only for the time that you've spent on this, but the time to take to this committee to help us to understand more about how we should think about these transfers and what lies ahead. So both of you will appear before the committee and have things in writing. Anything you bring in writing, we would encourage you to leave for our awesome stenographer. More importantly, without objection, we'll enter that into the record. I'd like to, at this time, yield to the gentleman, the ranking member from Massachusetts. The gentleman is recognized.
Well, thank you, Mr. Chairman, and I know we're doing two bills here today, but with regard to H.R. 5226, I just have to say, we're only scheduled to be here for a couple more weeks until we come back after the election, and I just find it hard to believe that instead of providing funding to adequately fund the Zika crisis or dealing with the situation in Flint, Michigan, or dealing with the epidemic of gun violence in this country, we're doing this bill, which is a partisan attack on executive rulemaking processes that is never going to see the light of day. But you're in charge; you can do that. On the second bill, I'm happy to, on H.R. 5351, happy to welcome Congresswoman Walorski and Congressman Smith. I have great respect for both of them. Congresswoman Walorski and I serve on the Agriculture Committee. She's the chair of the Nutrition Subcommittee, and I'm the ranking member that subcommittee. And I have a great deal of respect for her, and I like her, so I can't really grill her on this. But I do want to say that I think this is a bad bill. And I'm looking at a letter here from Major General Michael Leonard, who was the first commander of the detention facilities in Guantanamo after the 9/11 attacks. And he sent a letter to all of us basically saying that instead of advancing efforts to defeat terrorist groups like Al-Qaeda, Guantanamo has become a strategic liability for the United States. He says our enemies use Guantanamo to bolster their propaganda, and our allies refuse to cooperate with us on counterterrorism matters if the result will aid ongoing detention operations at Guantanamo. He makes a very strong case why this base has become such a detriment to our national security. But then he says, legitimate concerns have been raised about the risk of transferring detainees out of Guantanamo, but he says there exists a robust review process to evaluate each potential transfer before it is effectuated. The Department of Defense, Office of the Director of National Intelligence, Joint Chiefs of Staff, Department of Homeland Security, Department of Justice, and State Department sign off on each and every transfer out of Guantanamo. And pursuant to federal law, no Guantanamo detainee can be transferred unless the Secretary of Defense determines that such a transfer is in the national security interests of the United States and that measures can be put into place to mitigate any risks that the transfer could pose. If there are concerns about the transfer review process, Congress can and should examine that. However, to categorically block transfers from Guantanamo and hold detainees there indefinitely, irrespective of the facts of each case, is unlawful and counterproductive. And so, again, as much respect as I have for the gentlelady from Indiana, I strongly oppose this bill. And again, I wish we were taking our time in this committee to address the Zika crisis or Flint, Michigan, or the floods in Louisiana, or the gun violence in this country. We're only here for a little bit. I'd like to think we could use our time to do something that would actually benefit the American people. And I thank the gentleman, and I welcome our two witnesses, and I yield back my time.
Thank you very much, and I appreciate the gentleman taking time to thoughtfully articulate his ideas. As we all know, we have not left yet. I anticipate that we will have the opportunity to address the issues that Mr. McGovern not only spoke about, but will be done in a way that's clarifying to the American people about us working together. Unfortunately, sometimes these matters require people to be in the same room, people to deal with the issue in the House in one way, the Senate another, and then the President to offer that negotiation. I believe that the gentleman is aware that the leadership, both sides, the House and Senate, Republicans and Democrats, met with the President. I hope it results in something that would be beneficial to all of us. As the gentleman knows, we're trying to work through these issues, including funding the government, to ensure that that these matters are well in hand before there's any recess that would be involved. And I thank the gentleman for his feedback. I'd like to make an announcement. Yesterday, there was an announcement that was made that Hugh Halpern, who is the staff director for the Rules Committee, would be moving to Speaker Ryan's staff with the departure of Ann Bradbury, and he'll be responsible for the Director of Floor Operations. I also announced yesterday, after we had left, that the gentleman, Stephen Cody, who is our number 2 guy here, will be becoming our staff director. So Steve Cody will do that. Steve has worked for the Rules Committee since January 2011 and has served as deputy staff director for more than 2 years. Previously, he served as director for legislative affairs at the office and budget under directors Rob Portman and Jim Nussel, and as House liaison under Josh Bolton. Steve began his service on Capitol Hill with Senator Connie Mack and continued Lincoln Diaz-Balart, where he served as chief of staff. And he is an asset, I believe, to me and also this committee. And when you see Steve, no matter where he is, he's probably having too much fun right now, but he will be assuming these duties really effective immediately with a transition period that will take through the end of October. Secondly, I'd like to introduce Alyssa Clark, who's sitting right behind me. Alyssa has a birthday today. Alyssa is from Fort Worth, Texas, and came up with her grandfather, who is a cardiologist from Fort Worth, Texas, and she said she wanted to come to the Rules Committee to see Jackie Walorski, one of her favorite members of Congress. So I said, you just come right on over. But Alyssa, a happy birthday, kid. All right, she knows she can't say anything. So here we go. Jackie, we're delighted that you're here, and gentlewoman is recognized.
Thank you, Mr. Chairman. Chairman Sessions, Ranking Member Slaughter, and members of this esteemed committee, I am grateful to appear before you today to discuss my important legislation, H.R. 5351, to prohibit the transfer of any individual detained at Guantanamo Bay. I'm exceptionally grateful to Chairman Sessions and the members of this committee that have already joined in support of this legislation as co-sponsors. To those on this committee who may have concerns about the bill, I want to be clear what this legislation does and does not do. First and foremost, this legislation would not enact a permanent lasting ban on transfers. Instead, this legislation would halt any further transfers of detainees from the time enacted until either this year's NDAA is signed into law or until the President leaves office on January 20th, 2017. As a point of reference, when the President came into office, there were 240 detainees at Gitmo, with the largest transfer ever taking place last month. The number of detainees is now down to 61. When Hoosiers in my district hear these statistics, they are rightfully concerned that the acceleration of transfers is more about the President running out of time to fulfill a campaign promise than about the national security interests of the United States. Further, many of our colleagues and I are concerned by standards the administration is using to determine which detainees to transfer. For example, of the 15 detainees transferred to the United Arab Emirates last month, 8 were unanimously deemed by the President's task force as too dangerous to transfer, citing a high level of threat that could not be mitigated except through continued detention. Another one of the 15 was unanimously recommended by the President's task force for criminal prosecution because there was adequate evidence for a conviction. Unfortunately, of those 9 individuals, 6 had their cases reviewed in the first half of 2016, and in every instance, the board reversed the original decision and approved all of them for transfer. As a recently released unclassified report on detainees highlights, the individuals remaining at Gitmo today truly represent the worst of the post-9/11 era, like Khalid Sheikh Mohammed himself. Beyond concerns about the risk the detainees pose, there are also concerns that the agreements made between the administration and foreign governments accepting detainees are seriously lacking in strength, as the recent case of a former detainee who went missing in South America highlights. My language in this year's NDAA aims to strengthen this by requiring complete written agreements for any transfers between countries to be shared with the appropriate congressional oversight committees. As recently as last week, we heard the President say that he was not ready to concede that he cannot close Gitmo before leaving office. The week before, we heard a similar message from the Vice President. While clearly resolute in their goal to see the facility closed, from a national security perspective, accelerating transfer to achieve that goal puts Americans at risk. That's why I am grateful to stand with the national security leaders in this House on this bill and remind the American people that we are looking out for their security and their peace of mind. I'm grateful to Chairman Royce, Chairman Nunes, as well as Subcommittee Chairman of the Armed Services Committees, who have joined me as co-sponsor and in support of this legislation to prevent more dangerous decisions from being made. I think it's ironic that we just paused last weekend to remember the 15th anniversary of 9/11. The images from that terrible day brought back many memories of the sheer magnitude of the attack. And I will continue doing everything in my power to ensure an attack like that never occurs again. Once again, Mr. Chairman and members of this committee, I'm grateful for the opportunity to sit before you today to discuss this matter, and I'm happy to answer questions that you may have.
Thank you very much, Jackie. I appreciate that. Mr. Smith?
Thank you, Mr. Chairman. At the outset, let me say, unfortunately, there is General Dunford, Chairman of Joint Chiefs of Staff, is meeting with Chairman Thornberry right now. I'm supposed to be at that meeting, so I will not be able to stay for long after my opening statements because I got to get to that meeting as the bill's coming through. But I do want to make a couple of quick comments about the bill and about the transfers. This is not about closing Guantanamo Bay. We've had that debate in Congress. I think it should be closed. I agree with some of the statements that Congressman McGovern made. But we don't have the votes, and we recognize that. And the NDAA this year will once again make sure that Guantanamo Bay is not closed. But the question is on transfers. And the regrettable fact is a lot of the people who were brought into Guantanamo Bay initially were brought in some cases, without adequate facts as to why we were bringing them in. And many of these people have been cleared for transfer for years, for a very, very long period of time. And the impediment primarily has been finding a place to send them. Of the 61 remaining, and we're pretty much down to it, I forget the exact numbers, but I think there's somewhere around 40 or 45 who we've said we are not going to transfer them under any circumstances because the danger they pose is too great. But there are still others that remain at Guantanamo that have been cleared for transfer, where we have decided that they are not a national security risk and can be transferred. And this bill would block the ability to do that between now and probably the end of this presidency. And I think that is a mistake. Because understand what we're doing here as the United States of America. We are taking people and holding them without trial, without charges, and without any due process beyond the basic habeas corpus right, which they have. And I think that goes directly against the U.S. Constitution, directly against everything we stand for as a country. We do not lock people up and simply warehouse them without due process because we think they might do something bad when they're let out. There should be due process. And there has been due process for some of these that are still there, and it's been determined that we don't have anything to charge them with, we don't have any evidence that we could possibly use in court, and they have been deemed safe to transfer. And what the president has been doing is he's been working out agreements with different countries, trying to find people who will take these inmates, detainees, and I don't think we should block that process. The truth of the matter is, as I said, we're kind of down to the last few numbers here. There's not that many more transfers left that are available to be made. But if there are people being held at Guantanamo, and there are some who have been cleared for transfer, who we are not charging, who we do not have sufficient evidence against to charge or hold, then it is a violation of the fundamental Constitution and the fundamental principles of our country to hold them. I don't think we should preclude the president from making these transfers. We already have a process, as Ms. Walorski pointed out, where the national security, the DOD, intelligence, they all give their opinions. We all work through that process to find out who is eligible for transfer. This would completely block that and make it impossible. And we mentioned the numbers of there's 240 down to 61. Almost all of those people that have been transferred were cleared years ago to be transferred for all of the reasons that I've already stated. So to simply block these transfers, I think, puts us in the position of violating due process, of holding people without charge and without due process and in violation of the Constitution. We should not take this authority away from the president. And with that, I will yield back to the committee. And like I said, I do have to leave in just a couple of minutes. Thank you.
Thank you very much. Mr. Smith, we're going to go directly to you as a result of your desire and need to be in another meeting, so I would defer to the gentleman on your side to see if they had any questions for you. Gentleman from Massachusetts.
I just would like to ask unanimous consent to insert on the record the statement of the administration policy on this legislation, which says if the president were presented with this bill, his senior advisor would recommend that he veto it. And again,
Without objection.
I agree with what Mr. Smith said. I think that Guantanamo has come to symbolize everything that I think America is really not. I think and I agree with the general whose letter I read from a little earlier, that for the sake of our national security, we ought not to block the transfer of these prisoners. But on top of that, I really do believe we ought to close it. And I know we don't have the votes to do it, but I think it's become a stain on our human rights record. We're better than this, and the fact that we keep on clinging onto it and making it impossible for us to find alternatives I think is unfortunate. But I thank the gentleman, I thank the gentlelady for being here. I give back my time.
Gentleman just makes time. Thank you very much. Gentleman from Florida.
Mr. Chairman, I don't want to hold Mr. Smith up, or I don't have a question for him, and that was the question that you put.
And I do not mind coming back. What I'm suggesting is we're trying to comply,
Yeah.
get Mr. Smith through a process.
I understand, but like I said, I don't have a question for
Yes,
him.
sir.
So if you want to move, I
Yes,
may have a question for.
Yes, sir. I will let you come back to
All
Mrs.
right.
Walorski.
Then thank
Not
you.
any problem at all.
All right, thank you.
Mr. Chairman, is it okay if I depart? I don't, go ahead.
Mr. Polis?
No questions, thank you.
I've got a question.
Sure.
What should, you're suggesting, okay, maybe not 61, but how many are dangerous, in your opinion?
Well, from what I've seen, and I don't have the numbers in front of me, first of all, that's not the only question that's relevant, okay? Many of the people, now, when you look at the people who have been released from Guantanamo and you see the statistics of recidivism, a lot of it was people who, I mean, at one time, there was close to 800 people detained at Guantanamo. And most of the people who have gone back into the fight, the overwhelming majority of them are people who were released during the Bush administration when we didn't have a process for vetting these people properly. We now do have a very elaborate process for vetting them. But look, we cannot guarantee you that there's absolutely no danger from any of these people, but apply that to, the court here in the U.S. If you have someone who's been convicted of a crime and they've served their sentence, can you guarantee that this person isn't some risk to society? No. But can you simply hold them, incarcerate them, take away their right to liberty without due process? It's a balancing test, against the interests of due process and freedom and the risks that are there. And that's the balancing test that the Obama administration has gone through. And as I said, they've got a much better record than the Bush administration had in terms of the people they've released actually proving to be dangerous. So of the 61 that are left, I believe that there are, I want to say 16 remaining, and staff can correct me on this, who have at one time or another been cleared for transfer, deemed not to be sufficient danger to hold. And, if the president can negotiate a safe place to transfer those people to, I don't think we should block them. Like I said, we're not talking about a large number of people at this time, but we are talking about the fundamentals of due process of law.
Well, I find that interesting. That's why I asked the question. So you would say 16 of the 61 you believe could be subject to or in line for.
And my staff could help me out on that.
Well, I'm not asking the staff.
Well, no, I just,
But I am gonna.
I want to get the number. I just want to get the number.
About 16. And so I think that Mrs. Walorski and myself as a co-sponsor simply looked and said, look, in these last few months, I don't think it's appropriate, especially if Congress is going to be gone, and we scheduled this, and we are going to be gone, and there are other activities, that the president should stop that process. I would hate to look up and find out that KSM, Khalid Sheikh Mohammed, had gone.
He is not.
Well, I didn't say he was. I said I would hate to find out he was. And so since we don't know who is and who is not, I mean, there have been some pretty scandalous people who were released, and you can't judge everybody's behavior. When they're in one place and they say you might not judge them and they can turn.
There are no guarantees.
All I'm suggesting to you is I don't have the knowledge, so that's why it's easy for me to say I don't have confidence in releasing people now at the very end, and that's what this statement is, in my opinion. Does anyone else have a question for the gentleman? The gentleman from Alabama.
I'm sorry, Mr. Smith, I wanted to give you an opportunity if you needed to consult your staff to give us numbers. The question that was asked by the chairman was, how many of the 61 do you consider to be dangerous?
I forget what the number was.
I'm sure that's why we have staff to help us understand things like that.
Okay. I'm told that as many as 20 have been cleared by the board for transfer.
So does that mean the remaining 41 could be considered to be dangerous?
It means the remaining 41 could be considered to be so dangerous as to be untransferable. I guess I'd have to ask for your definition of dangerous.
Okay.
Well, I mean, you just gave it to me. I thought it was a pretty good definition, frankly. Now, have there not been some of the people who've been released previously who we have some information to indicate they've returned to the battlefield?
Yes, I mentioned that in the earlier statement.
So-
Just like some of the people that we release from prison commit more crimes. So maybe every time someone commits a crime, we should just lock them up and never let them out.
Well, but you would be fair to say these are not ordinary criminals. This is not apples to apples comparison to ordinary criminals that do go out and commit more
Well,
crime.
due process is due process, and if you have something to charge somebody with, and you think they have committed a crime, and you think they are, how dangerous they are to society is part of the calculation, and whether or not
in
you
fairness, I
release
think there are people that disagree that due process is the same for somebody that's committed a fairly small crime and somebody that's committed a terrorist act. I think there are different levels of due process there.
Well, there are, but there ought to be some level of process. And the problem with a lot of these people in Guantanamo, there's no evidence, okay? We're not trying them. I mean, if they've done what you've said, if they've committed those terrorist acts, then we certainly ought to be able to prove it in court. And, you know, we ought to be able to convict them. So that's the dilemma that we're in.
But if they're dangerous enough not to be transferred, they've done, there's some evidence out there to indicate that they're dangerous.
Absolutely. That's why I'm only talking about the 20 folks who have been deemed to not be a risk, deemed
But
to be
as I understand Mr. Walorski's bill, all it says is the president can't do it until he signs the NDAA or until he leaves office, whichever occurs first.
Right, basically
So it's not a complete block.
No, it's taking the power away from this president.
And this is a president who goes out of office in a few months, and the Congress is going to be gone during that time, and there'll be a new president in a few months.
You're right. I just don't see why this president should have that power taken away from it.
Well, I really appreciate your being candid with the information provided to us. By the way, I appreciate your service on the Armed Services Committee.
And yours as
You
well.
always bring a great level of erudition and understanding of the issues, and you try to be as just flat-out basic about it as you could be, and I really appreciate that about you. So thank you.
Could the gentleman just yield for one point of clarification?
Sure.
Yeah, I mean, I keep on hearing this line that, you know, the president's going to be out of office in a few months, and, I mean, I just want to make sure that we all are agreeing about the same thing. This president is the president until he leaves office. So he's just as much president on his last day in office as he is on his first day in office.
Yes, sir. But Mr. McGovern, I think you'd agree that we have some instances where presidents, as they're leaving office, make some decisions that we look back after the fact and say, well, that's a pretty questionable decision. Maybe we shouldn't have allowed him to make that decision as he was going out of office. As we had with President Clinton, when he made some decisions. As he went out of office, there were some pretty questionable decisions.
I just get a little frustrated when we diminish the legitimacy of this president, which I
Well,
think happens on a regular basis. And this is other-
Let's agree with that, but the bottom line is that I chose as a co-sponsor to look at this as a measure that I took the president literally at his word. He wants to shut it down, and that would mean KSM too.
Yes, no.
I'm not trying to debate anybody. I'm trying to say this was the measure by which the standard.
So
Sir?
I am trying to debate somebody, if I may.
Yeah, yes, sir.
He is not, and he has made it perfectly clear, that he does not want to release KSM. The question on closing Guantanamo is where he should be held. And KSM is actually in the process of being tried. He is one of the ones that we actually feel we
Right.
have sufficient
Right.
evidence to go through a court process. So nobody is talking about releasing KSM or the other four that are being tried with him. I just want to make that clear. I do have to go.
No, and I really want to comply with that, and I thank my friend and the gentleman from Washington for doing this.
Mr. Chairman, I thank
Yes,
him as
sir.
well, and I yield back.
Excuse me, just a moment. Gentleman yields back his time. The gentleman.
Yeah, I just was going to follow through just on the point that you just made. Do you perceive that if this were to become law, that it would be precedential such that it could apply to the next president of the United States?
I believe that where there is significant presence of an American viewpoint, and the president has had 8 years to do something and maybe waits till the final turn, and I believe it's unwise to make big decisions to the end. Yes, sir, I do. And I would like to be quoted in 4 or 6 or 8 or 12 years from now, too. Because I do not believe, I believe it's an issue that I'm going to say our two presidential candidates should be asked about and should debate. And they should have that topic as is instead of somebody making decisions at the last minute. Yes, sir, I do.
That's interesting. You said we would have another round, so.
Yes, sir, and I
promise.
promise that I will right now, and I'm going to do that right now.
Thank you, Mr. Chairman.
Ms. Wolarski, we're now going to come to the round where we get to talk with you.
Sure.
And I just want to say this, that I believe that some of the discussion that we've had here fleshed out some of the emotional scars that have come from this entire conflict. But I will never forget the day on 9/11, 2001, September of 2001, when we were attacked. This plotting, this attacks took place a long time before we were acutely aware of it, and it occurred. They were done by evil people who I believe still others like them exist in the world today, and I believe some of them exist down there. I believe they're unremorseful for the things that they have done and unrepentant, and I will just tell you that I'm delighted to be a co-sponsor bill, and I want to thank you for bringing this effort to us. Mrs. Fox.
I want to thank our colleague, Ms. Wolarski, for bringing this to us also, and say that this issue is very troubling, I believe, to the American people. I think what the president has already done in transferring these people, many of these people, to other countries where they are not being held securely is already a travesty. And I certainly do not want to see any of the people left in Guantanamo let out, and absolutely not some of the worst people. So I think this is something we have to keep reiterating, that this is where Republicans position themselves, and I hope many Democrats will agree. So I have no questions, but I thank you very much for your work on this.
Gentlewoman yields back her time. The gentleman of Massachusetts.
Yeah, well, I've made my position clear, and I have great respect for the gentlelady from Indiana. You know, we just have a very strong difference of opinion, but, you know, I too remember September 11th, and one of the things that I wanted to make sure of was that the terrorists didn't win any victories by changing who we are. And I look at Guantanamo as an example of where I think the terrorists won a little bit of victory, because I think it represents all the values that I don't associate with this country. And no one's talking about releasing dangerous criminals into, you know, letting them free. And due process shouldn't be a dirty word. Due process is due process for everybody. But anyway, having said that, I don't want to, I think I've said my piece, and I yield back my time.
Gentleman yields back his time. The gentleman from Florida.
Thank you very much, Mr. Chairman. The truth of the matter is there is a better way, and that is in an effort to undergird how important due process is to all of us in the United States. We could, and in my view, should have transferred all of these people from Guantanamo to federal prisons in the United States of America. And it causes me then to ask Ms. Wolarski a question that's probably rhetorical, and that's whether or not you know of any person either alleged to be a terrorist or convicted as a terrorist in the United States, not at Guantanamo, that has escaped from prison in the United States.
Well, I appreciate the question. I guess I appreciate your concern, but I would answer that question with this. I've only been in Congress for 3.5 years. The president has had 7.5 years to make his case for what he intends to do with these prisoners. Now, early on when I came in, they talked about the U.S. federal prison system. They talked about it, but there was never a plan presented to Armed Services Committee or to the DOD. So we've heard hypotheticals from the president. We've heard hypotheticals from the Defense Department. And I will tell you, you know, in my former world as a reporter and as a state representative, I covered cases not of terrorists that have American blood on their hands. I've covered prisoners all through the state and federal system in this country, and the issue of contraband flowing into federal prisons, including cell phones, is a great concern for me. And even the issue of security and where to house these people. I don't want these people, my district doesn't want terrorists with blood on their hands in the federal prison. 90% of Americans don't want these folks in America. And I guess my argument to you back is, they are in the absolute safest place they could possibly be, surrounded by water, with America's finest men and women protecting them, guarding them, and keeping contraband and any kind of malice far away. It's a system that's working.
Right. Ms. Wolarski, I've been to Guantanamo more times than a little bit, and I've been in and out of federal prisons.
As have I.
A lot. The question that I put to you, as I said, was probably rhetorical. The answer is no person that has been alleged to be and or convicted of being a terrorist in the United States, if I use the blind sheikh, for example, or the shoe bomber, and we could go on and on and on. But none of them have escaped the federal prison. The truth of the matter is, it's all about politics, and not in my backyard. You say that the American people don't, 90% of them don't want these persons in their prisons. Well, I guess the New York people then must not be in that category, because repeatedly we've had trials. And as a former federal judge, I can tell you that the better part of due process would allow that they be tried in America rather than in the system that we're in. You know, for most of us that went to college, at some point, maybe even those of you that are brilliant, studied Franz Kafka's book, The Trial. It's just plain wrong to charge somebody, convict them, and then hold them forever without really any due process. I think in the statement of administration policy that Mr. McGovern introduced into the record, one of the things that stands out that the administration says is, moreover, by purporting to prohibit all transfers of individuals detained at Guantanamo Bay, the bill would in some circumstances violate constitutional separation of powers principles and could interfere with the ability to transfer a detainee who has been granted a writ of habeas corpus. Now, Ms. Wolarski, I don't think in the next 2 months that I don't know all the cases and what they are in the pipeline, but I know their lawyers are active in trying to do what they can. But what would be your position if this were the law and a federal judge had ordered one of the Guantanamo detainees to be transferred pursuant to a writ of habeas corpus? Would you think that that would be a violation of the separation of powers?
I wouldn't agree with that from that federal judge. And I'll tell you this, for all the experts.
Why would it have to be a liberal judge? What is that? I mean, what the hell are you talking about? Well, I said a judge. It doesn't have to be liberal or whether you would believe it or not. Whether you would believe it or not, a conservative, strict constructionist judge would likely be more liberal than you would believe on this subject of due process.
Yeah, I didn't say liberal. I said federal.
All right.
A federal judge. So hold on there.
All right.
But look, I think that
I stand corrected.
That's okay. I think the issue is this. I've been to Guantanamo as well, and I sit on the Armed Services Committee. So for the 3.5 years I've sat here and listed classified and unclassified briefings as they come very, very often, and we've asked a lot of questions of a lot of folks. We are not talking about a long-term plan here. The president has not produced a long-term plan to transfer these detainees. What I'm asking is, while we are not even here, This president is on a rapid exchange program to move these detainees out of Guantanamo Bay. He reminded us last week, Vice President Biden reminded us 2 weeks ago, they're on a mission to do this. It's never a case of national security. It's always a case of beating a deadline. I'm saying the American people have a right to hear what the two presidential candidates plan to do with these detainees or until the National Defense Authorization budget is passed. So we're not talking long-term implications here.
Well, one of them has even advocated a new system of some kind, which I thought was crazy. I want to tell you, Ms. Wolarski, I served over a period of 10 years, 8 years on the Intelligence Committee. I was with the former chairman of the Rules Committee when Khalid Muhammad was apprehended. Portagos and I were on a Codell during that period of time. And a lot of discussion went back and forth. But one of the more telling things I can suggest to this body, for 20 years, I've been a member of the Helsinki Commission. In '06, I was elected as president of the Parliamentary Assembly of the Organization for Security and Cooperation in Europe. And if you can say that, you ought to be the president of that organization. 57 countries, including Russia and Canada. Canada and the United States make it a transatlantic organization. There was not a year that I was in that organization that there were not resolutions after Guantanamo came into existence and after 9/11, that there were not resolutions pointing out how this would be a magnet for recruiting our people. I made special arrangements with Secretary of State Condoleezza Rice for the then president of the Senate in Belgium, a woman named Anne-Marie Lezon, and two other members of the committee to go to Guantanamo. They did, and they did a report, and a part of that report reflects on international belief, at least to the extent that 57 countries thought so, that we were making a mistake and likely would cause additional harm. I certainly respect your view. I think in the final analysis that this is nothing more than just if you get a headline tomorrow, not you, Ms. Wolarski, but the Republicans, you get a headline saying that you passed something that, number one, is dead on arrival in the Senate, number two, would be vetoed by the president, and if it came back to us, it would be upheld. So fine. For 8 years, the general view here from some of us is that the intention was to obstruct this president from doing whatever he attempted to do. The Senate Majority Leader at one point even made it clear that his whole objective in that particular cycle, the last cycle, was to obstruct and allow that President Obama not be able to undertake things. Now we come to the end, and you have in many respects succeeded, and it's been nuanced considerably by the thought that this is some kind of legislation that's going to be better for, quote, the American people, unquote. I often wonder about how you all don't remember that Democrats got more votes than Republicans did in the last presidential election, which also should speak volumes to you when you use the term the American people. That said, I think that you get my drift, that this ain't going nowhere. And in the meantime, you will have succeeded. Not you, again, Ms. Wolarski, but the party that you serve will have succeeded in obstructing or trying to obstruct Barack Obama to do whatever it is that he attempted to do. The young man will have his legacy, and most of it will include the negativity that he was presented with and the lack of dignity that was allowed in many respects to him as President of the United States. I hope that doesn't happen to anyone else. I would add that former Secretary of Defense Gates, Chairman of Joint Chief of Staff Admiral Michael Mullen, and former U.S. Central Commander General David Petraeus have all advocated closing Guantanamo, and even President George W. Bush has made statements to the effect, and I quote him in part, the detention facility had become a propaganda tool for our enemies and a distraction for our allies. I hope those few words find you all in some measure of understanding with reference to how much this facility has caused considerable pain. Thank you, Mr. Chairman.
Gentleman yields back his time. Mr. Polis, do you seek time? I do not. Gentleman does not seek time. Dr. Burgess.
Thank you, Mr. Chairman.
Yes, sir.
I apologize for being late. But Ms. Walorski, it strikes me that, of course, this is not the first time we've had this discussion. If I recall correctly, when the president was inaugurated and sworn in, did he not sign an executive order closing Guantanamo and moving those people to prisons in this country? And was it not pushback from Democrats, particularly Democrats in New York, who did not want those individuals tried in Manhattan? I mean, am I remembering this correctly? We've been down this road before. The president had an opportunity. He had overwhelming majorities in the House of Representatives, a 60-vote majority in the Senate, and it didn't get done. And it didn't get done because Democrats in the Senate did not want this to occur. I think, if I recall correctly, Attorney General Holder told the president he would not be able to accomplish what the president requested, which was trying some of these individuals in court in New York City. So, I mean, I appreciate your effort to bring this. I think it is important. I think it's important to reemphasize to people why this facility exists. And I, too, have been to Guantanamo. I, too, am on the Helsinki Commission. But I think it's important to bring this up and have people understand why this is important. Yes, there will be a change in administrations next year. We don't know what it's going to look like, but the next administration, regardless of who it is going to have to address this issue, and I think it's important to bring it up, and I'm grateful for your efforts in pendency of passing the National Defense Authorization Act to make it just crystal clear where the House stands on this. And certainly I'd be happy to hear your thoughts on the issue.
Well, I appreciate your comments. And, you know, as I was saying earlier, in the 3.5 years I've been here in Congress, there's been no plan presented since then from the president to say exactly how he plans on closing this facility, what he plans on doing with these detainees. But, you know, even more than that, I started getting actively involved from my first NDAA on the Armed Services Committee of starting to add amendments to starting to shape and put parameters around some of these people because of the recidivism rate being well over 30% documented, because we knew and there was already traction on American lives being cost, blood being shed as a result of these guys back and re-entering into the fight. And so, you know, it's just been a very passionate issue to me because where I'm from in Indiana, which looks at very common sense solutions to a lot of issues, and, you know, folks come to me every day, why can't Congress do something about this? Why can't Congress do something about this? And then, you know, we send people to countries where we're not even allowed on the Armed Services Committee to see the agreements of what we're asking these countries to do and what they're capable of doing. You're not even available to read these in SCIFs to find out what, you know, what kind of transparency and accountability are we going to hold this president to. And, as those kinds of things have just come and gone and these parameters have been accepted in the National Defense Authorization budget, I think we're at a point in this country right now with the largest release just a few weeks ago with the missing detainee in Rio and the question of the Olympics, where is this guy going because they lost him? And I think with the recidivism rate and department officials actually saying to us on committees, there have been American lives lost as these guys have reengaged in the fight, I think that's enough. And I think one more American life is enough to protect. And I appreciate your questions. I appreciate your perspective.
All right, thanks for bringing the bill to us. Thank you, Mr. Chairman. I'll yield back.
Yes, sir. Thank you very much. The gentleman from Alabama, Mr. Byrne.
Mr. Walorski, I enjoy sitting next to you on the Armed Services Committee, and I've observed over the last 3 years that this is not something you just thought of in the last few minutes. You have been consistently and persistently concerned and working on this issue, and I appreciate your efforts. I want to make sure I understand what your bill does. Your bill would not tie the hands of whoever the next president is. She or he would still be free to make decisions once they've been inaugurated about what to do with these detainees.
Absolutely. It's a short time. It's in the gap between the time we are here, the time we leave here, and that gap that happens, and really at the conclusion of the National Defense Authorization budget when it takes over as well, and nothing more.
Okay. So it's a pretty limited bill from that standpoint. It's not a complete handcuffs on presidents in the future. It's just some limitations on this president. He goes out of office. Mr. Chairman, I remember when my children were teenagers, we had a rule that they had to be home by a certain time at night, and it's because I told them bad things happen after a certain time at night. My observation about outgoing presidents is not all the time, but there are occasions that you have opportunities at the end of a presidency for bad things to happen, and I do remember very clearly some things that happened at the end of President Clinton's presidency that I wish that Congress had put some limits on him about so that we wouldn't have had to suffer through that. So I think all the gentle lady is trying to do here is to make sure with regard to this particular issue, we've had specific threats by this president to let dangerous people go. Listen to what Mr. Smith said. Dangerous people, let them go. We should not allow him to do that, and we should give the power to the next president, whoever she or he will be, to make those decisions, hopefully in consultation with the Congress, which would certainly be different from what this president's done. And I yield back.
Mr. Byrne, before you yield, would you?
Gentleman yields back his time. Does the gentleman seek time?
Yes, Mr.
Gentleman's recognized.
Chairman, just to refer to our friend from Alabama, if you follow logically what you just said, then certainly 3 months out at the end of any presidency in the future, it should be that we should be concerned because he or she may do something dangerous during that period of time. And then you referenced President Clinton and what we wish that we had done as he was exiting office. Am I hearing you that a president should not have the power of pardon or commutation of sentences of people as he or she exits their office? Because it does appear in history that most of that exercise for a president takes place at the end of their terms. So is that what you're saying? And would that apply to others? And added to that, what would cause anybody to believe that if this became law, that whoever the next president is wouldn't be confronted with this same particular measure as precedent?
All right, so let me ask you.
And I yield to my friend.
Question number 1 and number 3 together. First of all, I'm not talking about a blanket prohibition. This is a prohibition on the threatened release of detainees who we now know are dangerous. I'm not making a blanket statement about everything. He certainly has plenty of powers between now and when he leaves office that I would not foreclose. I don't think it's appropriate to do that. But where he's made a threat to release dangerous detainees, I think it's reasonable for us to say, let's foreclose that. So that's clearly the answer to both 1 and 3. That's what we're trying to accomplish, but what I think the bill is trying to accomplish. On number 2, I think the pardons that were issued by President Clinton at the end of his presidency, or at least some of them, were not just questionable, I think they were wrong, plainly wrong. And he left office with a tremendous cloud over him for having done that. Now, I don't know to what extent Congress has the power to limit a president from doing that. I've not researched that issue. But I remember that clearly, and I remember reading at the time that President Clinton was rushing, and he is prone to rush a lot at the end of things. That's his way of doing things. He was rushing to try to get these things done. And it's my belief, and I'm not the only person who believes, is that in his rushing to do it, he used some very poor judgment. And perhaps if we foreclose them from rushing to do things at the end of their presidency, we would keep them from making mistakes they wish they did not make, and I think it would save all of us a lot of heartache.
Well, reclaiming my time, the logic fails again there, because when would be the point that they would be rushing? Let's say somebody is going to pardon someone that you don't agree that they should pardon. Would it be that 6 months out or 1 year out of a 4-year presidency? You understand what I'm saying?
Well, I do understand what you're saying. I'm not trying to get into an argument with you about pardon,
Well, I don't
because
mind that's about all that we can do up here in this damn place.
that's not Ms. Walorski's bill, let's face it. I mean,
Agreed, but
all I'm saying is
but
that
you
we have,
took it beyond that, Mr. Byrne.
but we have instances of presidents, whether it's this issue or other issue, in their rush to get out of office and make good on a campaign promise or make good on some promise they made to somebody that supported them, to do things that are questionable. And I think it's reasonable for us, when we have a direct threat, as we have in this instance, to release people who are dangerous, that we would foreclose him of that possibility.
The good thing
and I
is-
would leave it open to the next president. So the next president who will have to face this, I agree with you, they're going to have to face this, but let's let them face it, not at the end of a president.
All right, I yield
No,
to Mr.
since we're worried about bad decisions being made when people rush, I would hope that rule would apply to Congress. The fact of the matter is that a good deal of our business is done at the last minute when we're rushing out of town, to get home for a holiday, because we don't do our business always in regular order, unfortunately. And there are lots of bad things that get put in legislation that no one ever sees because it gets done at the last minute. Lots of decisions are made here in haste. And so, whereas we're all talking about rushing decisions, there's that old saying, physician, heal thyself. This institution, and we're going to see it again this year, because we have a major omnibus spending bill that nobody here will have read by the time you vote on it. And it's going to contain things that you're going to be surprised are in it when you figure it out 2 months later. This is the biggest culprit in terms of making rash decisions and rush decisions right here in Congress. So before we start trying to take away the power of the executive on their legitimate rights, we ought to look at ourselves and figure out how we can do business better. And I would argue the way we're doing business in this Congress really does, by any objective measure, is not the way we should be doing business.
I'd yield to the gentleman. It was my
I
time.
completely agree with you, Mr. McGovern, that sometimes we rush here as well. And I find those decisions to be unpalatable. And for that very reason, I voted against the omnibus appropriation bill last year. I did notice in a roll call article I just read, however, that Mr. Hoyer is quoted, and this may be, the press doesn't always get it right, is saying that your side wants an omnibus instead of the minibuses that have been promoted by some people on our side. So I agree with you. I think these last-minute decisions are bad, whether it's the executive or the legislative branch. I wish we'd just do our job. But there are forces on both sides of the aisle that work against that for their own interests. And I'm here to do my job and to do it right. And I think all that Ms. Walorski is asking of us in this bill is to provide a limitation on this president in a very narrow, limited set of circumstances to not be allowed to let people go who are dangerous. I yield back.
I just would remind the gentleman, I appreciate your conversation as pertains to Mr. Hoyer's quote in roll call, but Mr. McGovern's point's more salient in my mind. The Republicans are in charge here. Mr. Hoyer is not, and whatever ultimately gets to the floor will be at the hands of the majority, not at the hands of the minority. I yield back.
Gentleman yields back his time. Is there any other member that would seek time? The gentleman from Washington is recognized.
Well, thank you, Mr. Chairman, and just let me speak up for the non-attorneys in the room. We do appreciate listening to the debate back and forth of the nuances of law, so thank you very much for the last 15, 20 minutes. I just wanted to, today is September 13th, isn't that correct? 2 days after the 15th anniversary of September 11th, 2001. And I just would like to remind everyone that, the war on terror is still being waged all over the world, not just by the United States, but many countries are combating the forces of evil and terrorism all over the world. And so it seems just incomprehensible to me why we would want to let known prisoners of war who have been engaged in this conflict, who have taken positions contrary to the very existence of the United States. Why do we want to let them out to re-engage in this war that we are so desperately fighting, all because of a self-imposed deadline by Mr. Obama? And just to illustrate, I found some really interesting statistics, if I could read them to the committee, Mr. Chairman. They come from the Office of the Director of National Intelligence. And you might find this interesting because we've talked a lot about numbers, and Ms. Walorski and Mr. Smith shared with us some numbers of the prisoners. But as of January of this year, 2016, 676 detainees have been released from Guantanamo Bay. Of that 676, 118 are confirmed as returning to terrorist or military activities. 86 of those are suspected of returning to terrorist or military activities. So that's 204, or over 30% of those people that have been released have returned or highly suspected of returning to the battlefield in this conflict that we find ourselves engaged in. So to me, that just underscores the need to take a time out here, to not be compelled, to feel compelled to be up against a self-imposed deadline just in the last couple of months of this administration, no matter which president it might have been that had made this. It seems to me it makes sense to us, to me, as a Congress, to take some time on this. Give the next administration, whoever it may be, give this presidential campaign going on right now an opportunity to debate this important issue. So I just want to say thank you to Ms. Walorski for your work on this issue, and I appreciate very much your efforts in taking a pause on these actions. So with that, Mr. Chairman, I appreciate that.
Thank you, gentlemen. Gentlemen, yields back his time. Ms. Walorski, I want to thank you very much. As the committee, did you have a chance to ask all the questions you wanted?
Well, there's been
Gentleman's recognized.
Thank you, Mr. Chairman. It's been an interesting debate. The effort to close Guantanamo is nothing new. So, I mean, this is not like there's some deadline out of nowhere. I mean, this is something that the President has been working on, I believe, since he took office, with plenty of support around here as well. And I, the gentleman from Washington sort of indicated the choices are, let people go, or what those of us who advocate closing Guantanamo believe that those who should be prosecuted and placed in prison with a sentence for their crimes. So, I mean, that's the goal here. There's this, and I'm not an attorney like my friend from Washington. I mean, but I understand there's sort of this bizarre legal limbo about these detainees, and I think what, as policymakers, we want to get them out of that legal limbo. I mean, if there's a new designation under law that needs to be created, then let's create it. But in the meantime, what we have is people should be brought up and answer for their crimes, or they shouldn't be held. And if we're worried, and I would address very directly the gentleman from Washington, that there has been recidivism or people turning to become likely terrorists, I think many of us would argue that's because they were held extra legally for so many years that it has radicalized them. That's why many of us wanted to close Guantanamo 8 years ago. I strongly suspect that there would be a much lower recidivism rate. Many fewer would have turned to acts of terror or working with terrorist organizations had A, Guantanamo not existed in the first place, or B, we terminated the extra legal detention sooner. So those two are correlated, and the longer we maintain the extra-legal detention, the greater potential for increasing the ranks of those who serve our nation's enemies, whether it's detainees themselves or, of course, their family, their friends, their neighbors, who know, because of America's actions, that we don't live up to this great promise of rule of law that America is supposed to be about, and that we have an extra-legally detained their friend, their neighbor, their brother, their sister, their cousin, for an indefinite period of time without the process of law, further radicalizing those who would then threaten to do our country harm. So that's the danger here. It's why action is urgent. Frankly, it's why action was urgent 8 years ago. It's why action was urgent 4 years ago. It's why action remains urgent today. These are the same arguments we've always had around here. There is no arbitrary deadline other than that the president wants to do something, and that's not a change. That's something he's always wanted to do and has been working on for some time. So there are those of us here who want to facilitate that process. I understand there's those who want to delay that process, but this is not a new argument. This is something that we've debated many times around here, and until we have ended the extra-legal abomination that is Guantanamo, we will continue to make that argument, and I yield back the balance of my time.
Chairman yields back the balance of his time. Is there any other member that seeks time? Ms. Walorski, I want to thank you. I, too, have my own personal beliefs about the people who are left. I believe that they're vicious people who do not respect women or children. I believe that they're Islamic terrorists. I believe that they would do harm to anyone who got in their way. I believe the United States of America really did them a great favor and brought them into Guantanamo Bay. We have served their needs on a strict religious basis to meet their needs. We have given them food and clothing. We've given them camaraderie with each other. We have allowed them to have legal counsel. We have explained the charges against them. We have done many things, but I do not believe that they're entitled to constitutional privileges of the United States of America. I believe that it is a problem to extend those because under a court of law, information about completely related to their arrest and gathering of information, it would make a mockery of our intelligence group who would have to identify themselves in court. They would have to do things that would place many people at risk. Those that protect this country should do so without peril of their lives. And I want you to know that I believe that you're correct. I believe that what we've attempted to do is honorable and an American way to deal with a difficult problem. I intend to see the president at church probably in the next few weeks, and I'm going to remind him that that the actions that he took on behalf of a grateful nation, I believe, have saved us from much that was ahead, and the netting out of that has resulted in, I believe, America being stronger and safer, and I want to thank you for your time before the committee today. Is there any other member that's, yes, sir.
Mr. Chairman, just the statistics that I referenced, I'd like to ask permission to submit them for the record. They come from a summary of re-engagement of detainees formerly held at Guantanamo Bay by the Director of National Intelligence.
Without objection, we'll enter those in record, and I thank the gentleman very much. Ms. Walorski, thank you very much. I know you've been here a couple hours. Isn't it fun always to come up here?
This is my first time up here, Mr. Chairman, and I am amazed at the work that this committee does do. So thank you to all of you for indulging me as well. Thank you, Mr. Chairman.
Well, you did well enough to get invited back, so thank you very much.
Thank you very much.
Is there any other member that would seek to give testimony on H.R. 5351? Seeing none, this now closes the hearing portion of H.R. 5351. The committee would open itself up to H.R. 5226, Regulatory Integration Act, Integrity Act of 2016. The gentleman from Michigan is here. I saw that Mr. Clay was here. Lacey was here. There's Lacey. Lacey, welcome back. We finally got to you. Lacey, I apologize. It's taken some period of time for us to get to you. Gentlemen, thank you for taking the time this afternoon to be with us. As you know, we're delighted to have both of you, and we would make sure you know that we've already said that anything you have in writing will be near the record. The gentleman from Michigan is recognized.
I thank you, Mr. Chairman, and the ranking member for the opportunity to testify on my bill today. H.R. 5226, the Regulatory Integrity Act of 2016, is a good government transparency bill. The bill is a simple concept, but I believe it will have an important and positive impact on the public's participation in the regulatory process and the regulatory process as a whole. The bill requires agencies to be transparent about their communications regarding proposed regulations and other regulatory actions that are not yet final policy. In doing so, the bill requires agencies to disclose that the agency is speaking, rather than allowing the agency to send political messages through third parties. The bill also requires agencies to clearly state whether they are accepting public comments or considering alternatives. The public comment process that allows input from interested individuals and parties is important to the development of well-thought-out, effective regulations. The public comment process is also important for upholding our democratic values by enabling Americans to have their voices heard in the federal government's decision-making process. While Americans are able to vote for or against their elected representatives to hold Congress accountable, regulators face no such prospect. This drastically increases the importance of regulators taking public comment seriously. It is their only chance to voice real opinions before new regulatory law is enacted. Although individuals may disagree about how much regulation is appropriate or how intrusive certain regulations might be, we should all agree that the public's participation is a vital part of legitimizing the rulemaking process. Without input from the public, input that is fully considered by the agency promulgating the rule, there is something fundamental missing from the basis of regulation itself. Unfortunately, we've seen over and over again agencies that seem to believe that the regulatory process is simply a perfunctory act of compliance necessary to reach the end goal of whatever regulatory scheme the agency's staff feel it's best. And what we see when the agency diminishes public input is that the rulemaking process is used by the agencies to advocate for what should be a proposed rule, rather than use to refine and improve upon the agency's existing thoughts. In fact, Congress originally established the regulatory process as a way to crowdsource, if we might call it that, the development of regulations long before the term crowdsourcing was even a thing. This bill helps us return to our original intent of crowdsourcing regulatory efforts by preventing agencies from boasting to the public about how great their proposal is, instead of honestly and earnestly asking for feedback, constructive criticism, and a dialogue about how to best solve problems. Importantly, H.R. 5226 also includes provisions to help us conduct oversight of these new rules. Specifically, the bill requires agencies to post on their website some basic information about each communication the agency makes about a pending regulatory action. For each communication, the public will be able to see a copy of the communication, the intended audience, the method of communication, and the date the communication was issued. Additionally, agencies will be required to post online a description of each regulatory action, the date the agency first began to consider or develop each action, the status of each action, and the expected date of completion for each action. These basic transparency measures will allow Congress and the American public to verify that communication to the public about regulatory actions are honest, unbiased, and compliant with the requirements of this bill. It will also allow the public to have a central source for all communications about a specific regulatory action so that the public can have a full and equal opportunity to understand the intent of the agency if they choose to weigh in during the regulatory comment period. As a result, H.R. 5226 will restore integrity to our regulatory process, and I appreciate the opportunity to speak on this bill, and I look forward to any questions from the distinguished committee.
Mr. Wahlberg, thank you very much. Mr. Clay, I don't know if you know this or not, but one of your favorite Rules Committee members had a birthday earlier in the week. I do know. And Alcee, we didn't really celebrate, but we've acknowledged it, and we're really happy that he, made it up here and did everything necessary. So the guy smiling the most had an 80th birthday, Lacey.
I am so happy for him, and we will celebrate later.
Good. Gentleman's recognized.
Chairman Sessions and Ranking Member Slaughter, and as well as all of the Rules Committee members, thank you for this opportunity to bring minority members of the Oversight Committee's views to you now. I am not Ranking Member Cummings. He's the good-looking one. And I'm just here to share our views, and hopefully we can do that. I believe we can all agree that the proposed goal of H.R. 5226, which is to increase transparency of the rulemaking process by federal agencies. The bill, however, fails to accomplish that goal and will actually reduce transparency. I strongly oppose this bill because it is too broad, vague, and actually threatens to stifle agency openness with the public. This bill would prohibit federal agencies from making any public communication soliciting support for or promoting a pending regulatory action. Almost any action an agency would make to communicate the benefits of a rule could be considered promoting a pending action. There's already a criminal statute in place that prevents agency employees from engaging in grassroots lobbying for a proposed rule. The Appropriations Committee also typically includes language in appropriations bills that prevents agencies from using federal funds for, quote, publicity or propaganda purposes, end of quote. This bill goes beyond these existing restrictions to prohibit agencies from simply promoting a pending action. The bill also would prohibit an agency from making statements of, quote, aggrandizement. The bill also includes a number of absurdly burdensome requirements. Agencies would be required, for example, to list online the date, intended audience, and content of every public communication. That would make sense if it were limited to formal agency statements. It is not limited to that. It would include every phone call, tweet, or email. All of these communications would need to be reported. This reporting provision alone would make the bill unworkable, but coupled with the broad set of communications that could be considered promotion, it would lead to agencies limiting their interactions with the public, both to reduce their reporting requirement and to avoid running afoul of the law. According to the Office of Federal Register, the number of final rules published each year ranges from 2,500 to 4,500. Many of these rules can be highly technical. H.R. 5226 would hinder agencies from providing explanations for rules or plain language summaries of rules. With the large number and often highly technical rules, an agency should be able to communicate why a rule is beneficial. For example, in 2014, the Department of Defense proposed a rule to protect service members and their families from predatory lending practices. DOD's press release on the rule highlighted the benefits of the rule, such as, and I quote, this proposed rule would better protect active duty service members and their families from excessive debt. I hear the bells ringing, Mr. Chair, and so if my colleagues are serious about improving the transparency of the regulatory process, we should work together on a bill that would actually accomplish that goal. And we should not go forward with this bill. And I will stop there and answer any questions.
Mr. Clay, thank you very much. Both of you appear today and I know take opposite viewpoints. Mr. Wahlberg, tell me what happens today when agencies gather large amounts of information and then make a decision. Do they ever acknowledge the receipt? Do they ever add up, not the paper on one side or another, but do they take ideas and present them, come back and provide feedback to Congress, try and work with people, or they just go back into their own agency and then come out with something?
Well, serving as chairman of the Workforce Protection Subcommittee, we deal with Department of Labor, deal with the EEOC, Fair Labor Standards Act, we deal with OSHA, MSHA, Mine Safety, and they take plenty of information. Their rulemaking process goes on, there are dates that are given, people put the information in, but oftentimes we conclude that while people are responding to the original proposed rule, there's already changes that have gone on. And these same special interests that have great concern and great ideas, offering best practices in many cases, are now out of sync with what the department is already going on. And then we have agencies such as EPA, for example, that could have given information on the waters of the U.S. rule, for instance, in a non-judgmental or prospective way, by just simply asking for people's response to this, as opposed to saying, this is a good rule. We want your support in following up with information as well as letters in support of this rule. That's what we're getting at. It's stacking the deck against those that would offer, in good faith, information or concerns about a rule, and finding out that the decision's already been made, and the deck has been stacked against them, Mr. Chairman.
Thank you very much. Is there any Republican that seeks time? Is there any member of this, Mrs. Slaughter?
Thank you. Other than asking unanimous consent to put the administration's statement
Without
in the
objection,
record.
the
Thank
administration
you.
staff will be included. Any other members seek time? Thank you. Thank you to both of you for taking your time to be up here. Lacey, I hope you'll come back and see us sometime.
Certainly will, Mr.
Even on a
Chairman.
fill-in basis, I think you do a great job.
Thank you for your indulgence.
As always, you may count on that. Yes, sir. Good to see you. Mr. Wahlberg, thank you very much. Dr. Fleming, we're going to welcome you to the Rules Committee. Dr. Fleming, you have taken your time before to be up here in the most generous way, and I'm delighted that your timing was perfect to walk in right as you were here. So just so you know this, without objection, anything you brought in writing will be available. Please, for our awesome stenographer, and the gentleman's recognized.
Thank you, Mr. Chairman, and thank you, committee. Basically, this is opportunity to testify on HR 5226, which I thank you for, the Regulatory Integrity Act. My amendment requires agencies to include information about where a proposed rule would duplicate or overlap with other existing rules when they're making the online disclosure required by the underlying bill. Our economy and small businesses in particular are suffering under a wet blanket regulation and is particularly onerous. Was it not on? I'm sorry. It's particularly onerous when businesses have to comply with multiple sets of regulations. One area that it hits particularly close to home in Louisiana is EPA's methane rule and its overlap with BLM's methane and waste reduction rules. Louisiana's 4th District is home to the Haynesville Shale, one of our nation's largest resources for natural gas. Now BLM doesn't have authority under the Clean Air Act to regulate emissions. So instead, they've decided to regulate methane emissions under the rubric of managing mineral resources to capture royalty revenue. This is a poorly disguised attempt to double regulate those who produce natural gas on federal lands. And I can go further. I know, Mr. Chairman, votes have been called. But basically what this, without reading the entire statement, what this does is it actually requires in law that if there's any overlap in rules that be brought out and made a point of online, because that is a problem that we're suffering, certainly in my district, is the overlapping rules and regulations making it impossible to comply with all of them.
Awesome. Dr. Fleming, your ideas that you bring up here many times are based upon personal observations, and you are watching now many things happen in Louisiana, and you have watched them over the years. And I will tell you that you have probably seen the very best of the federal government and some of the things which need to be corrected over the years.
Right.
I just want you to know that I've watched your, not only work in Congress, but also the things that you do. And I just think it's amazing how you come and just try and make it better. You don't try and attack something, you just make it better, and I think that's what you're doing
Thank you.
today.
Absolutely.
And I
Thank
want to
you, Mr.
thank
Chair.
you for taking part in today's hearing.
Absolutely.
Is there any Republican that would wish to engage the gentleman? Is there any of my Democrat colleagues? Thank you very much.
Okay. Thank
We
you very much.
appreciate your time.
Yes,
Thank
sir.
you very much,
All right.
Dr. Fleming. Is there any other member that would seek to be heard on H.R. 5226, H.R. 5226? Seeing none, we will now close the hearing portion of H.R. 5226. And so we have now finished our work, and we're now getting our paperwork passed out, and the gentleman from Texas will be receiving that information. Well, we're going to hang out for 2 minutes. 2 minutes. Mike, Chairman now being receipt of a motion from the gentleman from Louisville, Texas.
Mr. Chairman, I move the committee grant H.R. 5351 to prohibit the transfer of any individual detained at the United States Naval Air Station, Guantanamo Bay, Cuba, a closed rule. This rule provides for 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Armed Services. The rule waives all points of order against consideration of the bill. The rule provides that the amendment printed in Part A of the Rules Committee report shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 5226, the Regulatory Integrity Act of 2016, under a structured rule. The rule provides for 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, an amendment in the nature of a substitute consisting of the text of the Rules Committee print 114-63 and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes in order only those further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by the member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent of the amendment, and shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report. Finally, the rule provides one motion to recommit with or without instructions.
You've now heard the motion from the gentleman from Louisville, Texas, Dr. Burgess. Is there discussion or amendment to the proposal? Seeing none, the vote will now be on the motion from the gentleman from Louisville, Texas. Those in favor signify by saying aye. Aye. Those opposed, no. No. Yeah, the ayes have it. The ayes have it. The gentlewoman asked for a roll call vote.
Ms. Fox? Aye. Ms. Fox? Aye. Mr. Cole? Mr. Woodall? Aye. Mr. Woodall? Aye. Mr. Burgess? Mr. Burgess? Aye. Mr. Stivers? Aye. Mr. Stivers? Aye. Mr. Collins? Aye. Mr. Collins? Aye. Mr. Byrne? Aye. Mr. Byrne? Aye. Mr. Newhouse? Aye. Mr. Newhouse? Aye. Ms. Slaughter?
No.
Ms. Slaughter? No. Mr. McGovern?
No.
Mr. McGovern? No. Mr. Hastings?
No.
Mr. Hastings? No. Mr. Polis?
No.
Mr. Polis? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk, report the total.
8 yeas, 4 nays.
The motion is agreed to, and the gentleman, the young gentleman from Alabama, Mr. Byrne, will be handling this for the Republicans.
And the ever erudite gentleman from Massachusetts.
Oh, Jim McGovern, that's not a guess, that's a fact. That's great, Jim.
What does that mean? No.
Erudite, that means.
Just teasing.
That means you like to eat
Fish.
fish.
Mr. Chair, are we meeting again this week?
So, good question. No other full committee meetings are expected this week, but we will have a subcommittee hearing day on proposed changes to the House rules. Chairman Stivers will be, that's the young man over there to our left, will be having a subcommittee meeting tomorrow at 10 o'clock a.m. Now, what does this actually mean to us? I am really not up to date, and perhaps you are, and know more about the Senate's action in moving forward and what those issues may be. I've heard about several other issues that may be coming back, but I'm hearing nothing that would approach us for this week. I'm hearing that Senate action may be taking place. They would gain the effective dates that they need the time. So, do you have anything to share?
Water resources and his DOC are starting today.
Yeah.
And,
So,
Mr. Chairman, what about, there've been press accounts that the majority is going to introduce a bill or legislation to slap Democrats on the wrist for
That's
demanding a
probably
vote on
gonna
gun
be
control. I guess, would that come to the Rules Committee, or would that be
That
under a
will be
privilege?
tomorrow.
it depends how it's filed.
But, all right, but
But
we have nothing on the schedule. You don't anticipate that this week?
Let me go back.
Well, it's coming up
I-
tomorrow.
I have no reason that we are scheduled, I have no reason right now to believe that we're scheduling any other full committee meetings this week.
They're
Thank
going to cut the MRA.
But I'm willing to,
Okay,
you
no,
know,
I just
somebody's
I'm
got a
trying to get my
better
schedule
idea.
together, that's all. Thank you.
okay, listen, thank you very much. I do take what we did today as a very difficult exercise, and I want to thank us for the way we tried to handle. I think Adam Smith and Jack, you're both most sincere about what they do. Committee.
Before everybody goes, I want to give our special thanks to you, who's been such enormous help to all of us and a member of the family, and we appreciate everything he's done, and we're glad he's going to stay here with the House of Representatives.
Yeah, you know.
And our best wishes to you. And congratulations to Steve, who is also somebody we know well and admire a great deal.
Yeah,
Appreciate
and
all
admire
of
more
you.
now. Well, I must admit, both of you were not in the room when we made the announcement. I will tell you, I was talking to Caroline Booth the other day, the person who needs to prepare this, and I simply told her, I have relieved Hugh Halpern of his duties. And she almost passed out.
Yeah.
And she became to understand what we were going to do. But Hugh, your time up here, I know, is only dwindling, or limited, but your service to both sides has, as we have seen on both sides, we have to work together and talk with each other. Great job, and you'll be missed, but we'll see you on the floor.
We dread telling Miles.
There's a lot of truth to that. Okay, we're done with our work for the day. Thank you.